Judge Hussain?
Betty, I see there's a lot of people missing still.
Yes, we short a few people, but we did say yesterday we are starting at 1 o'clock
I
sharp.
know. Just give it a few minutes.
Okay.
Um, how much time do we have after 4 o'clock?
If the recording stops, I will just press the record button again, if that's your problem. We did tell the delegates to keep a half an hour after
Okay.
4.
All right. And I'll ask them to send the questions to you, and then you can email them to me.
The chat function, sir.
Mm.
There was, yes, posted in the chat function.
Yeah.
Okay. Sir, I think we should start.
Right. All right. Good afternoon. Let's get started. Should you have questions, can you send them through to Betty Lubber, and I'll try and answer as many of them as I can, given the time limitations. Also, I must warn you that at 2 o'clock, there may be a slight disruption because we're going to go into load shedding, but my inverter will come into effect and we'll be able to carry on uninterrupted then. Okay, yesterday we were talking about sequencing the facts and the documents. Now, as some practical advice, as lawyers involved in dispute resolution, you should automatically begin to do a few things. It must be part of your makeup. It must be routine. And it's the following. Firstly, always get the facts first. Don't rush into sending even a letter of demand. By the way, letters of demand are dangerous things. Unless you are compelled by a statute to send a notice which amounts to a demand, such as in RAF cases or when you're suing the state, then send it. Otherwise, they are not necessary to institute proceedings. The problem with letters of demand is that they include in it a version or a set of facts And if you're not well versed in your case and you write a letter of demand, one thing is guaranteed: someone at the trial is going to contradict that letter, and then you're going to get into trouble. So always get the facts first. Number two, when you start listening to your client, two things should click in your mind. The first thing is, and I take it from me, this must be the first thing that must occur to you. Ask yourself, while listening to client, is this version probable? Is it likely to have happened? If it is not, if you don't believe your client's version, you will never sell it to a judge. That goes without saying. When you've got past the version being probable, ask yourself, can I present this evidence in court? Is it admissible? Okay. The fourth thing you must do automatically is ask yourself, is this story being told to me in a sequence? Is it sequential? Does it make sense sequentially? If it does not, use sequence. Now, what you see on the screen here is a reference to what is known as a chronology document, also known as a chronology table. Because chronologies are essential for your preparation and presentation of your facts in a trial, courts now are beginning to require the practitioners, attorneys and advocates, to prepare and present chronology documents or chronology tables. Those of you familiar with the rules in the SCA and the directives in the SCA, as well as in the Constitutional Court, and also in Gauteng, especially in the High Court in Johannesburg, the local division, the courts require now in appeals for the parties to file a chronology table or chronology document with your heads of argument. It's become compulsory. The same thing applies when you're filing your written argument in the Constitutional Court. You are expected to file a chronology document or table. In Gauteng, when you are in an opposed motion, when you file your short heads and your practice note, you have to file a chronology table. Now, why is that so important? It's because judges know that there can be a misdirection and an error of fact can occur because the judge and the lawyers may not have sequenced the facts. So always sequence the documents. Now, the next piece of advice I want to give you is that already now you should start learning how to draft chronology documents. Trust me, this is easy to do. You don't need a precedent. It's a 3-column document. The first column is the narrowest one on the left-hand side of your page. That's merely for numbering purposes. You number each item. The center column, which is your broadest column, is a description of an event. The third column on the extreme right-hand side is where you insert the time or the date when the incident took place. The document basically has a description of the material facts of your case set out in a chronological sequence. Judges appreciate it and they like receiving chronology documents. Now you are going to become involved in an action. I told you at an early stage, you're going to obtain the facts. At this stage, you already start preparing your chronology document. It's easy to do. You can open a file on your computer and start preparing the chronology document as you go through the facts. You will keep shifting the different incidents that that you that you are told about by your clients and by the witnesses and by the documentation. So once you have it on your computer, it's so easy for you to play around with it. And eventually, before you start writing your particulars of claim, you should have what looks like the beginning of a chronology document. Now, this has many, many advantages, and we'll deal with it later. One of the things you have to do is keep it on file, and then you'll keep updating it. The party's pleadings close. You may have to update the chronology document. Discovery takes place. You'll have to update the chronology document. By the time you are certified trial ready, you should have your final chronology document. It really works well if in your opening statement you say to the judge, "My lord, may I hand up a chronology document that I prepared for the court?" Hand it up to the judge. Judges appreciate it. At a glance, they can see what's going to happen in this trial, and that's important for you. I will say more about this as we go along. Now, the next step, you've got the facts now, is for you to work out your case concept. In a case concept means what actually happened according to your client's version. It's an absolutely crucial step, as the case concept will inform how each process going forward in the action is dealt with. Now, why do you need a case concept? Simple. As a lawyer, you need to know what happened according to your client's version. How can you possibly go to court? How can you prepare your particulars of claim? How can you state your cause of action? How can you draw a founding affidavit or an answering affidavit? How can you draft a plea if you don't actually know what your client's version is? This is extremely important, simply because you cannot, in the middle of the trial, or even during your pre-trial procedures, change your client's version. Now, trust me, this happens all the time. Where an attorney proceeds on a version, then client changes it. That causes contradiction. That is a serious flaw in your case. You have to avoid it. I would suggest you explain to your clients what is meant by case concept, that your client must be certain that this is the version, and that is the version you will take to court when the trial comes. It is the same version that will guide you in judicial case management conferences, in pre-trial conferences, and case conferences with your opponent. You develop the case concept from the facts and the supporting evidence you have gathered, which you have received from your client. From this, you have to formulate a cohesive and persuasive story to convince the judge that this is a true version of the events. The case concept will then guide you on how to proceed. It guides you from the moment you draft your particulars of claim all the way to the point where you draft your heads of argument for your final argument in the trial. So the first process, having obtained the facts, now you have to work out your client's cause of action. Now I must tell you, this can be one of the most difficult phases of the process. As a strategy, you cannot afford to get this wrong. First of all, you have to work out what is the cause of action. In other words, take a look at the material facts handed to you by your client. Is this a case involving contract, or is it dealing? Is it family law? Is it statutory law? Is it customary law? Is it constitutional law? So what you're going to do is look at the facts and then contextualize the law. Remember, the law is vast. You cannot research everything. By obtaining all the facts, you start confining your preparation based on the material facts of your case. Remember, do not work out your cause of action from a precedent. That's a mistake. So when you have worked out in your mind what area of the law, you have to draft your particulars of claim so that it discloses a cause of action, but it must be a sustainable cause of action. You know, lawyers think, well, I can always amend my particulars of claim. Amending particulars of claim is not a good strategy at all. What you don't realize is that if you amend your cause of action at a later stage, remember the rules say you can amend any time before judgment. Even during argument, you can seek an amendment. The problem with amendments is that they create contradictions. You see, when you amend your particulars of claim or your plea, the original document doesn't disappear. It's there. Your opponent has a copy of it and will always have a copy of it. It doesn't disappear. So now your opponent, during cross-examination, is going to look at what you drafted and now look at what you amended. There's going to be a contradiction. And then during cross-examination comes this most infamous of questions. Attorneys hate it when this question is asked during cross-examination. Did you tell your attorney? That is a dangerous question, and it's a lose-lose question for you. Because what the lawyer is doing is saying to the witness, look at what you instructed your attorney when these summons were issued. Now look at the amendment. It's a different story. You are contradicting yourself. You can't explain the contradiction. And there goes your witness's credibility. So you must be sure of your facts. Work out what area of the law. Now recognize a cause of action. Is this a claim in contract? Is it a claim in delict? Can I sue in the alternative in respect of both? Is this a matrimonial matter? Is this a matter involving family law? Is this a matter involving labor law? So you need to work that out. Now, here's a warning. And I know I'm repeating myself, and I do it deliberately. Whenever you encounter a set of facts or a version that seems implausible, in other words, you don't believe it, stop, clear it up. Do not proceed on the basis that, well, those are my instructions, I'll go to court. You are merely going to head towards a confrontation with the judge, because the judge is going to find this equally implausible. And the judge is going to say to you, listen, do you expect me to believe this nonsense? And then you are going to sound really pathetic when you say, well, my lord, those were my instructions. I've showed you the case law and I showed you the new trend. The judge might find you to be guilty of an abuse of process Or worse, the judge might say that you are an incompetent lawyer. So what is the cause of action? It is a set of facts. Now, don't think cause of action is all about the law. It does include the law, but first and foremost, it is a set of facts which, if you can prove to the satisfaction of a judge, will be recognized by the law as giving you a claim. Now, that's a simple explanation of cause of action. It is the facts that the law recognizes as giving you a claim. So how do you formulate a cause of action? There are a number of steps you can take. And I warned you, you want to become a good lawyer? Do not start with a precedent. My advice to you is draft without a precedent. Have a go yourself. Then if you want, take a precedent and compare and see if you got it right. Eventually, you will be confident enough not to use a precedent. Lawyers who draft using precedents invariably mess up the facts of the case, and it bites them seriously in a trial. What I recommend is you begin by writing down, using numbered paragraphs, the material facts of your case. Now, you're a smart lawyer, you will go to that chronology document you started drafting. And there you will see you would have written down the material facts in a sequence. Now already your chronology document is helping you. Here you extract all the main facts that represent what happened according to your client's version. You must record this on a separate document using numbered paragraphs. You must also itemize if it's a case where you are claiming damages either out of contract or out of a delictual action. You must set out the details of the damage. You must itemize it. At the end of the exercise, you will understand the context of the matter. You will know what happened and which area of the law is involved. That's the whole idea. If your knowledge of the facts is good, you should have no difficulty in identifying an appropriate area of the law. Now, there's the danger. If you are going to start this process with a flimsy knowledge of the facts, you are going to be misdirected and you are going to get your client into trouble. Usually in your practice, I would say 80% of your typical attorney's firms, the causes of action you will deal with on a daily basis are mostly contract or delict. You need to know how to draft this. You are expected, according to the rules, convey to the defendant in your particulars of claim what is being demanded of the defendant and what is the reason for the demand. That's what your particulars of claim must have. Now, once you've got the facts, only then do you research the law. Find out what the law says is the remedy. If there is a remedy, you should be able to prove the material facts of your case. So what happens is, you've got your material facts. Now, assume that you are able to prove this in court. You've got the witnesses, you have credible evidence. You will be able to persuade the judge to accept your version of what happened. Now look at the law and ask this question. If I can prove those material facts, what does the law say is my remedy? Now, when you've answered that question, you've basically got your first rough draft towards your particulars of claim. The law will tell you what are the essential elements or requirements or material facts for the chosen course of action. Now, it's a simple exercise. write these facts down. Okay, open a file, write it down. At this point, you would have written down two very important lists. Firstly, there's a list of the material facts, including the events that came from your client and the witnesses. You will have a list of the elements of the law that make up the cause of action. Where did you get that from? You got it from the law, from the law. You now have a legal framework for your cause of action. So what you have is a combination of the material facts and what the law says is the remedy you're entitled to should you be able to prove those facts. Now you see, there's a reasoning that applies, and I want you to grasp that reasoning. Now read through what you have written, and here are some practical questions to ask. Can my client's facts be sufficient to satisfy the essential elements of the cause of action? In other words, the material averments. If not, then there's a gap. Let's take a simple example. In a motor collision case, one of the material averments, the law tells you, is that you have to allege and prove that the cause of the collision was the negligent driving of the other side. You're all familiar with that. That's an essential averment. Now you have to see if your facts can satisfy that requirement. Take a contract. One of the elements is that there must be a breach of a material term of the contract. That's what the law says. Now look at your facts. You've got a contract, yes. You've got terms, yes. Was there a breach of a term? Yes. You are now complying with the requirement, okay? If you can't, then there are gaps in your version and you have to take further instructions. That's another way of saying you don't have enough facts. The question is, if I can prove these facts in court, what does the law say is my remedy? Now you'll notice that we are now just drafting the particulars of claim. And I'm stressing the fact that your particulars must be drafted after you've obtained all the material facts. The mistake lawyers make is that they don't get all the facts. They can get a summons out, serve it on the other side, they defend it, and months down the road, or even 2 years down the road in some cases, the lawyers have got more facts now. What they didn't look for when they started. And now they discover, oh my gosh, my particulars of claim are not supported by these facts. Now you have to amend. Amendments, I told you, are dangerous things. They also cause postponements, delays, and costs. It happens all the time. Go and sit in the courts here in Johannesburg or Pretoria, where we have a number of trials that will start on any given day. You will see that many of them are postponed. Why? Because someone needs to amend. Why did they need to amend? Because they didn't have the facts when they started. So you see how important it is. Then you ask as a lawyer, if these are my material facts, can I provide proof of the facts if the defendant opposes or disputes them and does not admit them? You need to know who will be my witnesses and will they be available? What do I need to support this evidence? Do I have documents? What is my client's version? Are there contradictions? Now, once you've answered these questions, you've got your cause of action. So you have two lists of facts. They represent the fact the law recognizes as giving your client a claim. So there's your cause of action. Two lists of facts. material facts of your client's case, the material facts that the law says you need in order to prove your case. Put them together and ask the simple question, can I provide proof of those facts? If the answer is yes, you're good to go. Okay? Now, I would recommend, you'll see on the screen this book. I know many of you have this book. It's prescribed by the Legal Practice Council. It's called Practical Drafting Skills. Get it, and it step by step shows you how to draft particulars of claim. My advice to you is have a go yourself. Write yourself. Do it yourself. Do not use a precedent. If you get your particulars of claim wrong, you get the wrong cause of action, or you are factually incorrect, you are off to a bad start. When you draft particulars, firstly, you set out a cause of action, and secondly, sets out the material facts of your client's version. Those material facts must support your cause of action. If you act for defendant, you must answer the substance of the plaintiff's claim. In other words, you admit, deny, confess, and avoid. You state the defense, the material facts of your defense. The rule tells you that, Rule 22. Bare denials are of no use to anyone. I told you, when a judge reads bare denials, they think, there's no defense. This defendant is just wasting my time. Then there's the question of onus. You have to apply your mind at an early stage of onus. As plaintiff, you will always bear the onus. But the duty to begin can change depending on how you plead, okay? So you need to apply your mind to this. If you are a defendant's lawyer, you have to try and avoid pleading in such a way that you attract the onus and the duty, you attract the duty to begin. Often, this is not avoidable. A good example is the plaintiff issues a summons based on a suretyship. Defendant does not dispute the signature. Defendant says, I admit the signature, but I'm not liable to pay the amount because I signed under duress. Okay? So now what happens? The defendant attracted the duty to begin. The plaintiff will come to court and say to the judge, my lord, here's the original suretyship. The defendant admits his signature. I rest my case. The defendant then has a duty to begin to prove the duress. Okay? So I've gone through the pleadings very quickly because this is a strategy course. It's not a drafting course. But if you get this book and use it as a guide, and that's how I wrote it. I wrote it as a guide. It's not written academic style. It's also a nice big book on which you can write your notes and so on. You will see that it's written very user-friendly. Short paragraphs, tick boxes, checklists, and you should be able to draft on your own. I know that as many as 60% of attorneys and advocates who use this book are actually drafting on their own. And that's really the goal. Eh? You must draft on your own. So pleadings have now closed. When pleadings close, you call your client in. And here's a neat checklist that you have to go through. How do the pleadings impact on your case concept? So now you know a little more about the case because the other side have told you what their defense is. How does it impact on my client's case concept? How does it change his version as to what happened according to your client's version of what actually happened? Will you have to make adjustments? Usually you will. But if you're a good lawyer and you got the material facts up front and you drafted carefully, you will not have a problem with having to adjust your case concept. Now you can make a note of what facts have become undisputed. Now, when the other side pleads, they will admit certain facts which were not admitted when you issued your particulars of claim. When you look at the defendant's plea, always check where they dispute a fact, but don't say why. Put that in the undisputed column. What it means is that this defendant doesn't have a basis in fact nor law to dispute. You should make a separate list of these facts for two reasons. One, you will go to a pretrial conference, either with a judge or with your opponents, and say, listen, you've denied these facts, but you gave no reasons. Are you willing to make an admission, or will you disclose why you are disputing these facts? Now, in the past, lawyers got away with this. They said, oh, we'll take instructions and revert, and they don't come back. Or they'll say, well, we don't have to, the detail is not necessary. Or they'll fob you off for some way. They'll fob you off. Don't fall for it, okay? If an opponent says, I will revert, you say, give me a date when you will revert. And can I have your revert in writing by that date? Because that revert becomes part of your pretrial minutes. But the second advantage of knowing what the now undisputed facts are is it now helps you to work out the probabilities. It makes you even stronger on the probabilities. If the undisputed facts support your client's version, you know you've got a good case. But if those undisputed facts support your opponent's version, you've got problems, okay? Which of your material facts now became disputed? So what you're doing now is you're looking at what is the defendant disputing? Which of your material facts which make up your cause of action is being disputed now? You need to make that list. Why? Because when you're preparing for trial, you are going to have to prepare yourself to present proof of those facts. You'll have to get the witnesses, get the documents, get the visual evidence, and be prepared to present this to the judge. It's what we call a proof analysis. You take a material fact in your cause of action and ask the question, how can I prove it? Who will be my witnesses? What documents will I need? Look at the plea. Does it disclose a defense? What is it? Now ask your client, can they respond to that defense? What do they say? Now remember, in all of this, there's still the option of going to the other side and talking settlement. There's still the option of mediating issues or mediating the whole matter, okay? And at this stage, once pleadings close, update your chronology document. Now, finally, you've got the plea. Can you identify what is the triable issue between the parties? Now, the pleadings are not clear about this. Very often your pleadings, even if you draft it carefully, doesn't actually say what the real issue is between the parties. In other words, what keeps the parties apart? What requires a decision by a judge to resolve an issue? You must now write those down, write those issues down. The reason being, When you go to your first case conference with a judge, the judge will request you to write it down. The judge will say, listen, I've read your pleadings. They're not too clear. What do you say are the tribal issues? In this province of Gauteng, you are expected to define it. The parties, that's plaintiffs and defendants' lawyers, have to get together and jointly agree on what the issues are. Ignore the pleadings, the judges will say, without reference to the pleadings. Just tell me what the issues are. If you can't agree with your opponent on a phone, call for a case conference. Better still, call for a conference with a judicial case manager, a judge. It is absolutely essential for you to know exactly what the issues are. During your opening statement at the trial, if you did not record what the issues are in your minutes of your pre-trial conference or in your minutes of a case conference, the judge will want to know, first thing, tell me what the issues are. And that's what we did in the opening statement. By the way, it's impossible to prepare for trial if you don't know what the issues are. And I know this sounds so obvious, but I've spent many years in court where I've seen lawyers turn up in court ready for trial, and they're really not sure what the issues are, and they're not really sure what the client's version is. But they're there. They're going to run a trial now. Okay? Well, you can't do that anymore. You'll get found out. So now we get to a very important part of your strategy, your pre-trial strategies, and that's discovery. Discovery must also include e-discovery. Once you've identified the issues, now you see again how important the issues are. You have to identify the relevant documents you require, which you will then discover. Now, you will do what we call a proof analysis. You would have worked out the issues. Which issues or what are the material facts in your particulars of claim which the defendant disputes and which you will have to prove? Now ask yourself, what documentation will I require to prove those facts? Oh, documents are essential. I'll tell you why. Because judges love it. Judges like documents because a document represents an external piece of evidence, of concrete evidence that says to the judge, here's proof that this transaction happened, or here's proof that this witness made this statement. Here is a document that says defendant owes me money. So judges like what we call contemporaneous documentation. It is highly persuasive. It gives the judge one more reason to make a finding of fact. Okay. Now, the technique is to only discover the documents that are relevant to the issues before the judge. Don't go beyond that. In the past, we discovered everything in the court file, everything. And we ended up with hundreds of pages that were then put into bundles and handed to the judge. Courts do not allow that anymore. We want narrow discovery, not wide discovery. You will be penalized with a cost order if you discover hundreds of documents which you will not need in court. Okay? Now, this is something that you must manage between yourself and your opponent. Now, this is where the cooperation actually happens. You need to talk to your opponent, have a case conference. These are my documents. These are the issues. Here are the documents that I think are relevant. Do you agree? Can I see your relevant documents? And we're only going to discover that. And this is just practical advice. When you consult to obtain the facts, always be alive to the possible or potential presence of contemporaneous documentation. These documents are crucial to discharge your client's onus. Those of you who do commercial disputes, be it in arbitration or in a trial, will know that the entire case turns on documentation. Our courts, I told you yesterday, do not tolerate opposed interlocutory applications regarding discovery. Disputes around production and proof of documents are supposed to be resolved between the parties. Only where the lawyers can't agree on the production of a document or on the authenticity of a document, on the admission of a document, you go to a case manager and obtain a ruling in chambers. The trick is, before you approach the case manager, you must sit down with your opponent and you have to discuss with your opponent, these are the documents, which are the documents you'll admit. Let's separate the documents that will require proof from my side. And if you are disputing the documents, tell me why. Okay. That's very important. Now, I told you yesterday, these days, all the documentation that you will come across will be produced in would have been written in on a computer or on an electronic device. Now we have what is called electronic discovery or e-discovery, and that's the way it is written. It's lowercasing e, uppercasing d, and that's the correct reference. It is the retrieval of materials originating from a computer, and it also extends beyond computer files to encompass the analysis, gathering, processing, review, and production of discovery materials in electronic format from start to finish. The basic principle is that information which is stored, used, or transmitted in electronic form should be available through discovery with the same openness as traditional forms. With discovery, we require transparency. The parties have to produce all the documentation, even those documents that are against you. Okay. There is a book that was written by myself and Terry Harrison called A Guide to E-Discovery in South Africa. That book, it's still very useful, but we are busy writing an update. So there's an update coming up later this year or very early next year, maybe January. So keep an eye out for it. Now, just before I move on away from e-discovery, I may explain to you yesterday, with electronically generated documents, as a lawyer, you need to, at an early stage, look at the source of the documents. Where was it produced? Which computer? Who produced it? Where's the metadata? Can I go and secure the metadata? How will I secure it? How can I ensure that there will be no interference with it? Then you will present that to your opponent, obtain admissions. If you can't get an admission, then you're going to have to prove the authenticity of the document. in which case you'll have to apply your mind to what we call chain of custody evidence. From the point when the document was drafted, saved on a computer, um, details appear in the metadata, you saved it on a hard drive, no interference, who was in charge of that hard drive, where was the hard drive, there was no interference, and then someone printed the document. So there's a chain of custody that you will have to prove. Now I'm going to move on to case conferences. I can assure you that when you go to a case conference, be it with a judicial case manager or not, if it's with your opponent, you can win your case right there. Case conferences are absolutely crucial methods of preparing yourself for the trial. You must never underestimate the value of case conferences. You see, in the past, we never had case conferences. We never talked to each other. In fact, you never saw the other side and their attorneys until you got to the first day of the trial or your first Rule 37 pre-trial conference. And even then, attorneys used to brief counsel to go and do these pre-trial conferences, and you never saw the attorney. You only saw the attorney maybe on the day of the trial. Well, we know now that the whole idea behind being less adversarial is for the parties to be more cooperative and to attend case conferences. You can do these things virtually from your desk on Teams or Zoom, and it doesn't require you to drive somewhere and find parking and all the rest of it. Your judicial case management, most of them are being done virtually, especially in this province. The other provinces where the courts don't have Wi-Fi even, like in KwaZulu, those courts, Durban, Pietermaritzburg, they don't even have Wi-Fi. So the judges, if they want to do it virtually, they have to go home and use their Wi-Fi from home. It's quite ridiculous, but hopefully that will change. So you are encouraged to cooperate with your opponent. Case conferences will also be called by a judicial case manager, that's the judge. You attend case conferences, you are expected to be to actually achieve the purpose of the conference. I told you yesterday, you are not to merely comply, you must actually serve the purpose. And you are expected to keep minutes of the conference. Judges take these conferences very seriously. Depending on which division you are practicing in, the minutes of the pre-trial conference are scrutinized to actually decide whether or not you are ready and whether or not a trial date should be given. So it's a very important step. And there's another warning here. Go and read Rule 37.9a. You will see the judges have the powers to penalize the lawyers with cost orders. This 37.9a is not a new rule. It's been there for ages, decades. We never used it. I don't think I ever used it even once on the bench. Now that's changed. I've come across judges making cost orders in terms of Rule 37.9a against the lawyers. Okay. So what do you expect in these case conferences? Before you attend, and I say write it down, what you believe are the triable issues. Often, it does not emerge from the pleadings, okay? Write it down separately. Actually, there's a very funny story I must tell you. Here in Johannesburg, when we introduced case management, we had this case management court. We also have it in Pretoria. The Western Cape High Court has it too. I'm not so sure you have it in KwaZulu. But we had a form which one of the judges put together, of which must evidence all the steps you will take in order to become trial ready. So it dealt with things like, are there going to be experts? Give details. Have the experts met? Have you filed the joint minute? Did you agree on the discovery bundles? You know, things like that. But it had one paragraph which used to cause the lawyers endless trouble. That paragraph read, state the issues for trial. So what the lawyers did, they wrote in that paragraph, see pleadings. It was quite clever, actually. But the pleadings didn't actually tell you what the issues are. So the judges had to amend that form. The amended form reads, state the issues for trial without reference to the pleadings. That's what you're supposed to do. You know, don't go to a pre-trial conference if you don't know two things. One, a thorough knowledge of the facts. Two, your case concept. And three, what are the issues? If you don't know those three things, you are going to be embarrassed in a case conference. You will look like an idiot. Okay? No one wants that. So be ready. Now, the point is, if you prepared the way I'm telling you, step by step, there's method in it. You can't go wrong. But if you're a lazy lawyer, you don't do the work, you are going to get into trouble. And I warned you, these days, you get found for incompetence or negligence, you end up paying a serious price for that. One of the purposes of pre-trial conferences is to reduce the number of issues between the parties. So you can't reduce issues if you haven't first defined them. What we did in this province, we reintroduced the commercial court. This is a court where, by application to the DJP or the JP, you can ask for a commercial matter to be referred to the commercial court. The reason we did that is to attract commercial cases back to the High Court. You know, commercial cases have fled the High Court. They're all gone into arbitration. There's nothing on the roll. So we brought in this commercial court. The benefit, we said, was that it will immediately be allocated to a judicial case manager. In other words, one of the judges who are specially selected to sit in this commercial court. There, one of the things the judges do is that they look at the particulars of claim. They'll call an early case conference and they'll deal with this. They'll say, okay, what's the cause of action? What's the defense? What are the facts that are admitted? What's in dispute? And now tell me what's the issue. So you need to have an agreement or an understanding with your opponent about the issues before you go to a case conference, okay? The best method is to hold the meeting with your opponent without the judge. You can do it virtually and say, listen, let's agree on the issues. It's only where you can't agree. Then you tell the judge you couldn't agree, the judge will help you. Also request your opponent to write down what they believe are the issues. Put the two lists together and you'll be able to come up with an answer to the question, which the judge will inevitably ask you, what are the tribal issues? When you go to pretrial conferences, we said that one of the purposes is to try and reduce